I've been given the high sign, so I'll start now. I'm Larry Silverman, a judge on the D.C. Circuit. And our topic today, of course, is the impact of the antitrust paradox. Now, I have to tell you that I play one minor but crucial role with respect to this book. Bob Bork and I were at AEI when he was working on it, and he was explaining it to me, and he asked me, he couldn't think of a title. I thought of the title. It's the only contribution I made to the book. Of course, it has had an enormous impact, and we're going to hear more and more today as to what impact it had. We have four distinguished panelists. Rick Rule is a partner at Paul Weiss. He was former head of the Antitrust Division. And as my recollection, although it's not here, he comes out of that hotbed of free market economics, University of Chicago. Joshua Wright is a university professor at the Global Institute and holds a courtesy appointment in the Department of Economics. He's a leading scholar in antitrust law, and we're fortunate to have him here today. Next, we have Susan Creighton, who's co-chair of the Wilson-Sonsini-Goodrich Antitrust Division, and she has served in the Federal Trade Commission as Director of Bureau of Competition, which, as I remember from my days in the Justice Department, was perceived as enemy number one. Next, and final, we have Andrew Finch, who's here to defend the worst parts of the Justice Department's Antitrust Division. That's not fair. He claims he's not responsible for anything that's controversial, but he's the Principal Deputy Assistant Attorney General for the Antitrust Division. So I'll give them all 10 minutes, and then we will have an opportunity for cross-pollination and attacks.
Thank you, Judge Silberman. Thank you to the Federalist Society. It's always a pleasure to speak to you all, and particularly on a topic that is actually fundamental to antitrust. This panel is supposed to talk about the generational impact of the antitrust paradox, and it was truly great. However, I think its principal impact and where the book itself shifted things was more in the courts. And you can see its lasting legacy in the decisions of the Supreme Court, the Courts of Appeals, and the District Court. At the Department of Justice, where I was in the 1980s under Ronald Reagan, it was actually the antitrust paradox you can think of more as a window into what the policymakers there were thinking, as opposed to a sort of guiding light. There were a number of us who actually went to the University of Chicago, and the one thing about the Antitrust Paradox is it's a great book, but it really does kind of distill the essence of what the Chicago School was. And those of us who had gone to Chicago had essentially been imbued with those values. The first head of the Antitrust Division was Bill Baxter, who was not, I will say, and maybe his defense, a Chicago schooler, but Bill had worked with Bork. They had been on the Neal Commission in the late 1960s together. And Bill was a strong advocate of the use of economics in antitrust. There were, though, others. I came to the Antitrust Division in late 1982. Doug Ginsburg followed shortly thereafter. We both went on eventually to be the head of the division. but along the way were very much involved in the policies of the agency. But in addition to us, there were a number of other Chicago school grads. Ron Carr was the first, one of Bill Baxter's deputies. But there were others like Dale Collins, Deb Garza, who's here, all of whom essentially brought what they had learned, just like Bob Bork brought what he had learned to the Antitrust Paradox. We brought it to the Antitrust Division. The Antitrust Paradox, its influence and the Chicago school's influence, really, in my mind, can be identified in four areas. The first and maybe the most important was a recognition that antitrust was a law that reflected an economic policy, and that economics should be the sole sort of animating guideline of those laws. And if you go back to the 60s and early 70s, a lot of what was happening in the agency, in the courts, was driven by social concerns, political concerns, and others. That was largely swept away by the paradox. The second, and the one that most people cite the book for, is the concept of consumer welfare, which is, to me, and I'm going to mention this a little bit more, I think something that has lost its original meaning. When Bork used the term, he was reflecting the fact that competition generally will optimize total welfare of society, both allocative efficiency as well as technical efficiency, giving people incentives to improve technology, lower the cost of goods, and therefore maximize the output of society's limited resources. That concept of consumer welfare really did, if you will, serve as the basis for the Antitrust Division at the time, courts, to modify the rules to make sure that they were helping to promote consumer welfare as opposed to inhibit it. Sort of related to that was the notion that output and a practice's expected or likely impact on output is the critical measure of whether or not one should be concerned about particular conduct, unilateral or joint. And last, and one that maybe is not commented on as much, I think Andrew might talk about it a little bit, was the notion that there are costs to the rules of enforcing the antitrust laws. If you go back and look at the Antitrust Paradox, one of the points that Bork was very clear about was not engaging in balancing, because of the sense that that was really beyond the competency of the institutions that had to implement the law. Ultimately, that concept, and I would say that if you want to understand what was going on in the 80s and how this generational change occurred, you should read the Antitrust Paradox together with The Limits of Antitrust, which is an article that Frank Easterbrook wrote in the Texas Law Review in, I think, '84. But I think even better than the Antitrust Paradox, The Limits of Antitrust point out the limitations on the enforcement agencies. That sort of notion of the rules and having efficient rules is a little bit different in terms of how Baxter viewed the law and Bork. Baxter was more of a person who believed in the direct application of economics to solve problems. For the antitrust, for the Chicago schoolers, it tended to be more of an indirect way to structure rules, but not a sort of belief that economics was the end-all, be-all, and could answer all questions. The Antitrust Paradox, the Chicago school, did pretty fundamentally change the way antitrust was applied and was viewed in the late 70s through the 80s, when we left in 1989. But since then, and I'm going to just mention these three things, I think there's another panel that's going to maybe talk about the legacy of the Antitrust Paradox. But from my perspective, looking back over what's happened in the intervening 28 years, I think that the meaning, to some extent, of the antitrust paradox has been lost or at least distorted. First, and I've talked about this before, the concept of consumer welfare, which was kind of an ingenious semantic exercise by Bork because associating it with the consumer made it very powerful. But he was talking about total surplus. Subsequently, people have essentially said, no, consumer welfare is really just about consumer surplus. And there has come to be a modification or redefinition of the term to limit it to consumer surplus. That was not what the book says. You should go back and read it. That was not what Chicago School considered it to be. But I think it's had some deleterious effects on enforcement in the intervening years. Second, there has been this tendency to substitute price for output as the measure of the impact of a particular transaction. In many cases, price and output are opposite sides of the same coin, highly correlated, but that's not always the case. And the sort of focusing on price and the impact on price to the exclusion of the impact on output, I think, is another source of deleterious results, and I think has exacerbated the problems with the change in the meaning of consumer welfare. And third, there's the role of economics and economists. Again, as I mentioned, there was a recognition in the antitrust paradox, clearly a recognition in the Chicago School, that you have to look at the institutions that are implementing rules. You have to look at the limitations of economics in terms of being able to generate outcomes. I think to some extent we've lost that. And rather than being sort of an intermediate step and point of analysis to develop efficient rules, there has been, to some extent, a substitution for economists in terms of deciding things. Now, professional economists love it. It's certainly increased their market power and their value. But I think it really overstates the predictive value of their models. I mean, for one thing, the models that tend to be used in merger analysis these days, I think most people know this, but I'm not really sure, they are actually constructed to show price increases. So the fact is, those are built in. So then you run the models and you go, prices are going to increase. And, surprise, surprise. But that doesn't mean that prices, in fact, are going to increase. There are a lot of different things that affect the economy, that affect people's decision-making, that's very hard to capture in a model. And again, I think that's a very serious deviation from where the antitrust paradox set us off. And just to sort of encapsulate it, I'm going to close with a joke we used to tell back in the Reagan administration about a Soviet Day, Labor Day parade. And the story goes that an American visitor was sitting there with his Soviet host, and along came the soldiers, the million-man army, or whatever it was back in those days, of the Soviet Union. Then came the tanks, then came the jets, then came, the ICBMs. And finally, at the end of the parade, along came 20 guys and gals that were kind of scraggly, poorly dressed, looked a little absent-minded. And the American turned to his host and said, okay, now I get this sort of parade that, you were going all the way up and showing greater and greater Soviet might, but I don't get these last guys. Who are they? They go, you don't understand, comrade. That is the most destructive force in the Soviet Union, our economists. So, again, that was, kind of our view at the time. I think there's still some truth in that nugget. So thank you.
Joshua Wright.
On that note, an economist walks to the panel, full of destructive might, I suppose. I think my get this up here. Comparative advantage on the panel sort of may come from two dimensions. one, I'm an economist, also a lawyer, but spend most of my time thinking about law and economics, and can speak a little bit about what I think the legacy of the antitrust paradox has been for industrial organization and antitrust economists in the world of law and economics. And second, a panel entitled The Generational Impact of the Antitrust Paradox. I think it may be appropriate that I follow Rick, given that I was born the year that the book was published. And it really is, I think, in a different way. I sort of grew up in the Chicago school tradition. So by the 90s, a bunch of folks at University of Chicago had decided California looks warm, I will go there. Harold Demsetz, Ben Klein, Armin Alchian, and the like sort of started the UCLA economics department, fondly called it then Chicago West. And would tell fond stories of the Chicago workshop room and hurt feelings and professors crying. And this was sort of the academic tradition that I grew up in California at UCLA in the economics department. So I want to spend a little bit of time talking about for an antitrust economist coming up, thinking about antitrust, sort of receiving the book as my first marching orders for hey, you're interested in antitrust, you start here and come back and talk to me, which were the set of directions I was given to by Ben Klein when I showed up in his office when my first day at UCLA. There are other lasting generational impacts, and I think Susan and Andrew and also in the next panel we'll talk about it. It's difficult to underestimate the influence of the antitrust paradox in accelerating and indeed probably causing the adoption of the consumer welfare standard in antitrust law. Assistant Attorney General Delrahim mentioned some of those benefits, and I think they're well understood in the antitrust profession. Maybe what's less well understood, before I get to the economics, is the influence that has had not just in the United States, but internationally. Dean mentioned some 130 some odd jurisdictions around the world who now have antitrust laws compared to a handful you had to think about if you had a multinational merger 20 years ago. Now you've got such a deal in front of you. You are worried about Brazil and Japan and Korea and China. One agency now was 3. You've got a lot on your plate in the modern antitrust world with various forms of divergence in those 130 jurisdictions. At the Global Antitrust Institute with Judge Ginsburg, essentially what we do is run around the world and try to teach antitrust economics to judges and regulators in as many of those jurisdictions as we can touch. And I will tell you, from firsthand experience, your mileage may vary on how advanced some of those jurisdictions are, on how committed they are to the consumer welfare standard, but it is a constraint of some sort on each and every one of them. There are very few jurisdictions that feel like they can replicate the antitrust mistakes of the US in the 40s and 50s without being paid attention to. Some have absorbed those lessons better than others, but I think the reach of the lessons from the book you see in those international jurisdictions, and probably the first order impact, maybe the most important impact that we see today from the adoption of the consumer welfare standard isn't felt in the United States, where we largely, but not always, argue with inside that framework and have debates over particular cases or evidence in particular cases, but agree largely on the framework. These are small debates. Overseas, we're having the large debates, and the impact of the book, I think it's sort of important to mention in the new sort of modern global antitrust world. It's just sort of how important that influence, how far that influence extends. In terms of the influence of the book on antitrust scholarship in particular, coming to these debates and in the opening keynote, A.G. Delrahim, I think, correctly described sometimes the caricature of the Borkian views, whether they be on originalism or antitrust. And sometimes in antitrust scholarly debates, you'll hear, well, the Bork view was make everything lawful and walk away. It's too long of a book for that. There's more in it. Most of the debate, my reaction coming to it as law and economics professor is most of the modern debate is taking place with folks who haven't read the book. So maybe the best news of the day is that the Federalist Society is working on a reprint. And so maybe that will improve the quality of debate that is had. The Chicago school that I grew up in, going to graduate school in the late 90s and early 2000s, both in law and in economics, looks quite a bit different from that caricature. The theory of the firm, one of the big I/O topics in industrial organization, the biggest, baddest debates were between multiple Chicago schoolers. You had Bork and Coase and Ben Klein and Harold Demsetz, all with different views and sometimes at each other's throats over those views. The modern view the view sometimes attributed to Bork that vertical integration or vertical restraints can never be anti-competitive. You just need to read the book. Says pretty clearly, in theory, yes, skeptical empirically that the case happens too often, but very open to empirics. Debates over resale price maintenance, debates over appropriate criminal sanctions, a point for price-fixing cartels, a point often missed in describing the Chicago school. It was Chicagoans, first Bork, later Judge Ginsburg, who argued for introduction and expansion of criminal sanctions and other sort of creative sanctions like debarment for price-fixing cartels precisely upon first theory and now some empirical evidence that perhaps there's under-deterrence in those areas. An intellectual monolith pointing to less enforcement. Bork was not, and nor was the Chicago school. I think points that are often missed in the current debate, but in the academic setting, sort of quite important. The generation of scholars that was born, certainly from my generation, and I think a generation of Bork students prior, extended the tethering of antitrust to economic method and all that it meant to all of the corners of antitrust. The tethering of economic method to antitrust meant not just economic theory, which is largely the debates in the economics journals at the time. Now those debates are usually more empirical, but debates that I think, from my reading of the book, Bork would have embraced. Those two were part of scientific method, and those two were part of what it means for a body of law to embrace economics. It means updating your priors when the evidence changes. It means being interested in testing theories against the data, and that's precisely the sort of intellectual exploration that I think takes place throughout the 400 some odd pages of the book. But perhaps I think in terms of the generational impact, and I will close with this thought, the most important thing the book did in terms of scholarship and intellectual energy around antitrust was create a platform for I think I'm the third generation after, whole sets of generations of scholars to work on. In that sense, for law and economics sort of fans in the room, I think it's no coincidence the book, not only that it came out of Chicago, but around the same time as Richard Posner's treatise on economic analysis of law in 1976. That one's shorter, but it says a lot. It's a first order cut at virtually every problem in all of law and economics across all fields. 40 years later, I read that thing. I find things I disagree with, but it's the start of hundreds of literatures. It was the birth of, millions of hours of intellectual energy and research going into important questions. Got a lot of guys tenure too, me included, so thanks for that. And I think the antitrust paradox is really the equivalent in antitrust. We're 40 years past the debate Bork started with original scholarship on vertical integration. And 40 years later, there are journal articles published finding exceptions to what remains sort of the primary theoretical foundation that Bork set forth 40 years ago. There's empirical testing saying, we've got two theories, and now let's test them against each other and sort of see what the empirics tell us. That sort of tethering to economics, I think, not only in the narrow sense of particular debates that Bork engaged in, but also in precisely how the strength of the tethering, the strength of the commitment to antitrust institutions like the DOJ and FTC, to antitrust doctrine, and also to antitrust scholarship, to economic thinking, I think all owes itself to the intellectual energy and to the approach taken in the Antitrust Paradox. I will end with that. Thank you.
Susan Creighton.
Hey, good morning. Thank you so much to the Federal Society for having me. So while Judge Silberman's experience with the Antitrust Paradox begins before the book even had a name, and Rick's with 1980s Reagan-era enforcement a few years after the book was published, I wanted to pick up the story where I first came across the Antitrust Paradox, which was in the mid-1990s, about 15 years after the book's original publication. At that time, the Antitrust Paradox had just been recently reissued. I'm very glad to hear that may happen again as a further update. And at the time, in the early 90s, it had a new introduction by Judge Bork. As reflected in the new introduction's title, The Passing of the Crisis, Judge Bork's mood regarding the state of antitrust had lightened considerably compared to the time that the book was originally written. In 1978, Judge Bork had described his assessment of antitrust as striking, quote, a note of Teutonic gloom. He had then described what he perceived as a general movement in antitrust, quote, away from the ideal of competition and toward the older idea of protected status for each producer, away from concern for general welfare and toward concern for interest groups, and away from the ideal of liberty and toward the ideal of enforced equality. I think he viewed he underscored his concern with these trends because they saw them as of the utmost seriousness, ultimately, quote, incompatible with the preservation of a liberal capitalist order. Now, by comparison with this sober assessment from the 1970s, by the mid-1990s, Judge Bork had concluded that, quote, the decisive, if disguised, political content, close quote, that used to characterize antitrust decisions had by that time almost entirely disappeared. It wasn't that there weren't mistakes being made in the antitrust cases, but they seemed to arise from mistaken economic analysis rather than from an egalitarian ideology. Now, it was at this juncture in the mid-1990s, shortly after its reissuance, that I first became familiar with the book. I had not taken antitrust in law school, and maybe just since we've touched a little bit on the international scene, I might say that the only contact I had with antitrust, this is in the mid-1980s, was in a transnational law course where they picked antitrust to be their example of a uniquely American law. So try to what's the law that would most maximize conflict with other countries? Antitrust was it. Now, fast forward another 10 years, and I was involved in representing Netscape in the investigation that eventually became part of the Justice Department's lawsuit against Microsoft. During that investigation, I got to know some of the other partners who were representing other complainants, and one of them was a young partner named Joe Simons, now familiar to some of you perhaps as the chairman of the FTC. Joe and I became friends, and I knew that Joe knew antitrust and that I did not, maybe confirming a suspicion Rick has had from time to time. So I asked Joe for his help in getting up to speed on antitrust. He says, there's this book you should read, and it was The Antitrust Paradox. So for me, The Antitrust Paradox has always been the book on antitrust. I might actually say, if it's sort of outside my remarks, in an amazing coincidence, I was carrying the book on the way to the conference. Dashing out the door, I ran into one of my partners who's not a conservative, and he saw that I was carrying the book, and he said, "Oh, that's funny that you should be carrying the book." He didn't know I was coming to speak here. He said, "I was just having breakfast with a first-year law student," and he said, how should I get to know antitrust? And he said, "You should read the Antitrust Paradox. It's all you need to know to be able to counsel people on any antitrust question." So for any aspiring law students out there, apparently that's Joe's advice is still good and current. But for me, back sort of to the 1990s, unencumbered, or one might say uninformed by any pre-existing notions, I'd like to offer just a few thoughts on why the book at that time may have had such an outsized impact on others who, like me, were part of a general audience and not specialists in either antitrust or economics, much less partisans of the Chicago or any other rival economics school. I would say, to begin with, that the antitrust paradox was not just big one stop sign critical of all antitrust. Josh touched on that just a few minutes ago. To the contrary, as Judge Bork himself stated, his views were, quote, not prescriptions for the non-enforcement of the antitrust laws, but rather for their enforcement in a way that advances rather than retards competition and consumer welfare, close quote. I think sentiments that Assistant Attorney General Macon Delrahim just articulated a few minutes ago. So, for example, for Judge Bork, he identified two particular areas where he thought antitrust was under rather than over-enforced, and these are in the book. The first area of concern was of under-enforcement that he flagged was price fixing. I think Josh touched on this a little bit. Judge Bork wrote that price-fixing cases deliver more consumer welfare for the enforcement dollar than any other kind of prosecution, but in his view, inadequate resources had been dedicated to their discovery and punishment. Notably, one of the reasons that Judge Bork gave for adopting the consumer welfare standard was that it provided the justification for a per se rule against cartel agreements. He wrote, quote, if other goals such as small producer welfare are admitted, cartel price fixing cannot be illegal per se. A defense is possible and a full trial is necessary in order to weigh the interests of producers against those of consumers. Interestingly, the very next sentence was, quote, similarly, efficiency-enhancing integrations cannot be automatically lawful since their effect will be to harm some rivals. So for Judge Bork, per se condemnation of cartels and solicitude, his word, for efficiency-enhancing arrangements went hand in hand. In his view, those who would argue, as some do today, for per se price-fixing rules, but also for antitrust condemnation of some efficiency-enhancing conduct, they are taking positions that cannot be squared. In addition to greater focus on per se misconduct, Judge Bork flagged a need for more attention to the predatory misuse of courts, administrative agencies, and regulatory bodies, and private quasi-governmental groups like organized exchanges. Judge Bork, in fact, devoted an entire chapter to the problem of predation through government processes, noting that purchasing a delay of a year or several years through conduct before an administrative agency, quote, does not require that the predator be able to impose larger costs on the victim, that the predator have greater reserves than the victim, or that the predator have better access to capital than the victim. No other technique of predation is able to escape all these requirements, and that fact indicates both the danger and the probability of predation by misuse of government processes. Now, since the time that Judge Bork wrote those words, I think he would likely agree that these two areas are ones where antitrust in the United States has, in fact, shown significant improvement. On the criminal side, for the past few decades, I think that there has been a strong bipartisan consensus at the division favoring rigorous cartel enforcement and the commitment of substantial resources to that task. I think Judge Bork might find it not a coincidence that this bipartisan consensus has coincided with the firm establishment of the consumer welfare standard as the singular goal of antitrust in the United States. Since the antitrust paradox, the abuse of government processes has also become a major enforcement priority, particularly at the FTC. Under Chairman Muris at the FTC in the Bush II administration, we devoted significant resources to challenging anti-competitive conduct carried out through the misuse of government process. That included collusion by movers, dentists, lawyers, and the like, acting through quasi-government organizations, for which they claimed exemption under the antitrust laws under the state action doctrine, the misuse of government standard setting in cases such as UNICAL, and the misuse of agency processes at the FDA and the Patent Office. I expect that Chairman Joe Simons, who also served in the Bush administration, will continue to make the misuse of government process a major enforcement priority. Although the Antitrust Division has not in prior administrations made the abuse of government process quite as much of an enforcement priority, this administration's recent roundtables have actually specifically flagged these issues, including concerns regarding exemptions and immunities and anti-competitive regulations, suggesting a welcome commitment of resources by the division to this important area of enforcement. In short, Judge Bork's positive enforcement agenda has largely been translated into reality at the U.S. antitrust agencies. If Judge Bork's identification of what is good antitrust looks like it has come largely to mirror U.S. antitrust enforcement priorities, his condemnation of other types of claims has also coincided with their continued marginalization in the United States. Writing in 1978, Judge Bork noted that the core problem with U.S. antitrust law was the failure of the Supreme Court to give proper weight to the crucial concept of business efficiency. When efficiency is not counted or when it is seen as a positive evil, it appears that no business structure of behavior has any potential for social good, and there is consequently no reason to uphold its legality if any remote danger can even be imagined. Today in the United States, it's relatively rare for efficiencies to be successfully condemned as unlawful barriers to entry. Claims of leveraging of market power from one market into another tend to be met with some skepticism, and it is unusual for challenges to business behavior to be condemned because some remote danger can be imagined. Not coincidentally, there remains a strong mainstream consensus within antitrust, stretching from Diana Moss to Carl Shapiro to Josh Wright, that the consumer welfare standard is the single appropriate goal of antitrust policy. In the Antitrust Paradox, Judge Bork noted the views of some at that time, in the words of Judge Posner, that if only we would stop thinking so much about the problem and throw the book at the bastards, our monopoly problem would be solved. Those voices are starting to be heard again in the United States, which I think is the subject of the next panel. But these voices are generally outside rather than inside the field of antitrust. Indeed, Carl Shapiro, I think, recently testified before the Senate. He said, "I know of no serious antitrust experts who favor abandoning the consumer welfare standard and no workable alternative that has been proposed." My concluding note, however, and maybe here I would disagree with Josh a bit, is that I think that consensus exists in the United States. If you go out to practice beyond our borders, it's very much a pre-antitrust paradox world. Indeed, reading the Antitrust Paradox can sometimes feel like entering a time machine. Positions that Judge Bork was already describing as marginalized in the mid-1990s in the United States are still very much alive and with us in the rest of the world. Although Josh is maybe, and Judge Ginsburg and others in our agencies are laboring on this issue, I think it is not at all uncommon for those of us who sometimes find ourselves in other jurisdictions to find efficiencies being viewed as irrelevant or positively evil, for practices to be condemned on the basis of some remote danger that can be imagined without regard to actual evidence of competitive effects, or for conduct to be held unlawful because it provides a conduit for market power to somehow migrate from one market to the next. Again, not coincidentally, it is also common for competition agencies in those jurisdictions to favor the protection of small producers and special interest groups over general welfare, and for decisions to be based, as Judge Bork once observed with respect to past U.S. court decisions, on, quote, decisive if disguised political content. They have started to prioritize the condemnation of cartels, for example, as I think Josh noted, but they have not yet really internalized the consumer welfare standard or its implications. In short, perhaps a key difference between U.S. antitrust law and the rest of the world is that we have had the antitrust paradox, and they have not. Or conversely, perhaps they have not yet had their Judge Bork. In the U.S., however much people might disagree with this or that aspect of Judge Bork's economic arguments or his approach to particular antitrust issues, his core insights have become and remain orthodoxy here. In the running natural experiment that is the gap between the U.S. and the rest of the world on antitrust policy, the antitrust paradox may explain a great deal of that gap. Perhaps we need to issue more copies of the antitrust paradox, as Joe Simons once did with me as a novice in the field, say, here, just read this book. Thank you.
Andrew?
I'd like to begin by thanking Dean Reuter for the invitation and Judge Silverman for moderating and my co-panelists. It's terrific to be here. I'll start by building on the theme that this is a panel on the generational impact of the antitrust paradox. I have my own take on that. My dad attended the University of Chicago Law School and was in the class of 1959. And when I was in law school, he said, you must, I went to Chicago as well, he said, you must take antitrust, and he explained to me the history and going back to the course that was co-taught by Aaron Director and Edward Levy that he took when he was in law school, and he said, you must take antitrust and you must read the Antitrust Paradox. And so I did, and if it weren't for that, I wouldn't be an antitrust lawyer and I wouldn't be here today. Unlike many of the distinguished co-panelists here, I'm an antitrust litigator. I have the good fortune to be the principal deputy right now. But when I was asked to be on this panel, I asked myself, what could I possibly do to add value to what these folks here have to say? And I thought about that, and I decided what I would do would be to draw upon the experience and insights of many people at the division, some of the most senior lawyers and economists. So I got together with one of our esteemed front office counsel, Taylor Owings, who actually clerked for Judge Ginsburg and co-wrote an article with Judge Ginsburg about Judge Bork. And I said, let's interview some people. So we interviewed 6 people over the course of the last week, 3 lawyers and 3 economists. 2 of the lawyers started working at the Antitrust Division in the 1960s and are still there. 2 of the economists started at the Antitrust Division in the 1970s. 1 started in the 1980s and 1 started in the 1990s. So we also took a generational approach. We asked them several questions. We said, first, what was the impact of the Antitrust Division antitrust paradox at the division over time? How did it change the way the division does its work, and how quickly did that change occur? Second, what was the most important legacy that each of them could identify of the antitrust paradox for the work of the division? And third, what are the significant ways they could think of, if any, in which the Antitrust Division's work today diverges in some way from perhaps what Judge Bork had in mind? And then we invited them to offer any other observations they had to share. And so I'll report to you some of the fascinating answers that we got. The impact over time was not immediate. It didn't become assigned reading in 1978. In fact, the impact was felt gradually, and it really took off in the 1980s. Several said that the impact really began to be felt when Judge Ginsburg and Rick were heading up the division. After that, the economic insights that were injected into the work of the Antitrust Division increased over time, but we were told that doctrinal changes really sort of came about and were absorbed more indirectly as the Supreme Court introduced Judge Bork's thoughts into Supreme Court precedent. If you go back and look, the government did file a number of briefs in a lot of those cases, and of the, I think, 18 sort of seminal cases that cited Judge Bork. If you go back to the government's views briefs or the merits briefs, about 6 or 7 of them actually specifically cite and rely on Judge Bork's antitrust paradox in some way. One of our interviewees said that the impact ultimately, by the time the 90s came around, was so foundational that many people at the division today don't even realize the extent to which what they're doing was influenced and shaped by Judge Bork. And that same person said, "We really do stand on the shoulders of giants." When I asked about the most important legacies, we heard several answers. One of them you've already heard today, which is about the consumer welfare standard. One person said the book was a sweeping aside of non-economic values in antitrust, and Bork decisively won that fight. This person said, "I don't know where we would be if he hadn't done that." Someone else echoed it and said, "The most important legacy was the idea that consumer welfare was the object of the antitrust laws, that consumer welfare provided a single thing to try to measure and achieve, and that multiple other measures or values that had previously been the focus of antitrust doctrine could not and should not be traded off against consumer welfare." Interestingly, we also learned that the antitrust paradox transformed the relationship between economists and lawyers at the antitrust division. Before Bork, we were told the lawyers followed antitrust doctrine as set forth in the cases, as you would hope, and the economists would then come in and tell the lawyers how they were wrong. After the lessons of the antitrust paradox were absorbed, economists and lawyers at the division became more aligned, and the economists were trying to figure out how to prove the cases consistent with economics and how to help the lawyers explain the economics to judges. And one described this change as an earth-shaking change within the antitrust division. Areas of divergence. This is perhaps most interesting, but maybe unsurprising in light of some of the things that have already been said. Several people noted in different ways Judge Bork's emphasis on the need for antitrust laws to be administrable by courts and agencies. And of course, then there's a question about, well, what do you really mean by administrability? And maybe we can talk about that later. But one of our interviewees said, Judge Bork wanted simple policies to promote consumer welfare. Another said he was a realist in terms of what courts and judicial processes can do. And there was also a realism about what Judge Bork believed the limits of economics could be as well. And someone pointed us to a quote in the book where Judge Bork said, "Passably accurate measurement of the actual situation in a given case is not even a theoretical possibility." Someone else said that he thought determining costs and demand curves based on the specific facts in the market was a fool errand. And in the book he said, "Nobody knows these curves. Even the companies involved don't." As a result, one person told us that Bork wouldn't think that economic analysis should be driving every case, perhaps as some say it is today, and that he would say there should be more presumptions in antitrust law and in antitrust enforcement rather than case-by-case economic analysis. As a result, several questioned whether today's emphasis on extremely detailed, data-driven analysis is actually a divergence from what Bork had in mind, and whether presumptions should, in fact, be playing a greater role in judicial and agency decision-making. Finally, as to some other observations, one of them was that, and several mentioned that Judge Bork was a lawyer and not an economist, and how important that was in his ability to communicate economic concepts to lawyers and other judges and create a readable, impactful book. And then lastly, on the international front, it's interesting. One person told us, and this is particularly apropos of what Susan just said, that when he worked in the division's foreign commerce section in the late 80s and 90s and was traveling quite a bit to foreign other countries to do antitrust training, we were giving out copies of the Antitrust Paradox. And that he delivered many of them, particularly Eastern European countries, and encouraged them to read the book and understand it, and hopefully as a way not to have to go through the growing pains that our antitrust enforcement regime did, but to get started on the right foot. People will have divergent views as to whether that worked, but we should probably still be doing that. As a closing remark, I would just say that I was graduate student in philosophy before I went to law school, and there is a famous quote by Alfred North Whitehead, who is a Cambridge logician, and he said, somewhat famously, at least among philosophers, that most of modern European philosophy is but a series of footnotes to Plato. And that's actually an overstatement, but it's probably not an overstatement to say most of modern antitrust jurisprudence is but a series of footnotes, many in Supreme Court cases, to Judge Bork and the Antitrust Paradox. Thank you.
Well, I wonder whether the panelists would respond to Rick's 3 criticisms. I did count 3 at the end. Three concerns that the book has been used in some respects improperly. What did the rest of you think about that? Do you remember what he said?
I remember one of them in particular, which is not that one, which I do think the book has been used improperly, though I don't. I conceive of that criticism slightly differently. I think Rick was talking about misuse of consumer surplus versus total welfare for most of that point. I think the book is used improperly. I do agree in that regard; it is used improperly often, but also misused at times to caricature Judge Bork's positions. One of Rick's criticisms that I think came up also in Andrew's remarks is sort of precisely the role of economics in the economist and modern antitrust. That's one where I think we may have some disagreement. So in the spirit of starting a fight for the entertainment of the audience, I'll try.
Good. That's what I was hoping for.
So, there's no doubt when you read the Antitrust Paradox, there is skepticism about the use of economics to measure effects, to balance anything that sort of, jumps off the pages throughout. You can't estimate, there's a commonly cited line, you can't even sort of conceive of what these demand curves and cost curves look like, and so forth. There's sort of a little bit of Austrian economic influence emerging through the writing. So let's not measure, let's do, simple rules for a complex world sort of strategy for antitrust. No doubt that was his position. I think that's a natural function of being a good student and consumer of the state of economics in the 40s, 50s, and 60s. IO economists couldn't do that. The best we did was have sort of big aggregate cross-sectional studies across industries and make complaints about market shares. But economists estimate demand curves all of the time now. This is, not difficult to do because data availability, because of advances in econometrics. I would like to think, and maybe this is a fruitful area of discussion, for simple applications of industrial organization economics, market definition is not what it used to be. It involves serious measurement. We have natural experiments where we can estimate price effects, the sort of evidence that comes out, say, in a Staples Office Depot decision. I would think that Judge Bork would embrace that as being, if you were a consumer of today's economics, being the sort of stuff we can do reliably, we test it, it holds up well over time. But still rejecting another category. Rick mentioned merger simulations, and so I agree with him there. There's a category that's maybe still sort of a little too much hocus pocus and not enough real power in the studies that I think if we look at merger sims in particular, have had influence inside the agencies, but courts have largely rejected. And I think out of the same skepticism. And so I guess that's a partial disagreement and a partial agreement, but emerged largely out of what economics could do then versus what it can do now.
In other words, your bottom line is economics is now more sophisticated and therefore can be more simple.
Yes.
What do you think about that, Rick?
Well, look, obviously, I don't want it to be taken that I think that economics are inappropriate or pure sophistry. I don't. I think they're very effective in terms of constructing the appropriate rules. But, talk about merger simulation models. That's the principal area where the tools tend to be applied directly to try to come up with an answer. Okay, that's really the area where it comes up every day. And, the problem with it is that, now, again, I think Josh is absolutely right. Judges who tend to be lay judges and not, as imbued in all these things as most antitrust lawyers, often tend to kind of look through the models and not buy them that much. But they generate outputs that seem to suggest that an economist can tell you exactly what's going to happen to price as a result of a transaction. And the problem is that the models are structured to show that their price is going to increase. And you can do that, just so you know, in a deal where a company, in a vertical acquisition, where a company has like a 1% share and acquires the manufacturer of an input, the models will show that deal will increase price. Now, what economists will tell you is, yeah, but that's not entirely right because the models also incorporate efficiencies. But this is another aspect, and again, I refer you to the limits of antitrust, where I think Easterbrook really kind of fleshed out these points very effectively. But the problem with courts, and frankly the problem with agencies, is they'll buy in the models and they'll essentially swear by them that they show price increases. But when you try to show the countervailing efficiencies or increases in surplus in that regard, they are completely dismissive in a lot of different ways because they're very skeptical. They'll be very limited in terms of what they will credit as an efficiency that's valid, first. Second, they'll only take those efficiencies into account if they impact price. That's where the other point I made was the substitution of price for output. And the result is that, in my opinion, the way the agencies have approached mergers, for example, is they've been concerned about smaller and smaller, arguably more trivial problems, and have kind of ignored the benefits in many cases of mergers. And it's again a reflection not so much of bad will on the part of anybody, but it's sort of losing sight of Bork's insight about the limitations of the instruments of antitrust enforcement. And you can kind of predict that you're going to have those results. And I think that I don't think it really accurately reflects what Bork was talking about to basically embrace economics and to justify overly aggressive enforcement on the grounds that, well, hey, I can justify it on the basis of economics, so it's consistent with Bork. I think that's a misuse of the book and a failure really to understand sort of one of the fundamental precepts of the Chicago School.
Susan, you have a view of that?
I was actually, I think maybe Andrew goes first, and then I was going to comment.
I was just going to say that, one of the great, wonderful things about the antitrust division is that you have the economics analysis group with 60 or so PhD economists who you can call at any time and ask questions about economic issues, and you can't really do that in private practice without running up a bill pretty fast, a big one. But
Andrew, could you speak a little louder?
Sure. I was just talking about the economic analysis group at the antitrust division and how you can ask questions to them, and I've done a lot of that. And what's interesting is you can call up and you can say, well, what does economics have to say about this? We've got an investigation and there's a question. Maybe we have a vertical merger and you want to know, can you help us with figuring out some of the coordinated effects issues? There are still holes. There are gaps. There are places where economists and economics and no amount of data is going to help you. And sometimes you get that answer. And there's a concern that I have that that's lost. People think now economics can answer any question that you could ask in an antitrust case. Judges may expect that an expert will be able to testify and have looked at data to answer any question presented in an antitrust case. So I think it is important to remember that there are still limits and there are still gaps in understanding and gaps in theory. Merger analysis is obviously very well fleshed out in horizontal mergers, but there are places where there's still there are limits and there's ground for skepticism.
So I just wanted to make a comment on also on the role of economists in non-mergers. So I think I'm maybe going to agree with Rick in that context, and then also I think with what Josh probably would agree with me. At least I think I probably picked this up from one of his previous articles, which is I think economists have gotten sufficiently sophisticated with their models at this point that we often will see in the non-merger context economists being able to come up with theories under which one could say, in theory, there could be a problem here, and so hence this is an exception from sort of from the norm, if effectively that can, to the extent that then becomes sort of not subject to sufficient kicking of the tires, I think it can have the same kinds of problematic consequences that Judge Bork detected when judges were doing the same thing without equations. So I don't think he would have favored what can sometimes become people coming up with models about potential problems and then sort of using that to justify changing the law in ways that really aren't supported by any empirical evidence.
Rick, well, you had a couple of other objections, as I recall.
Yeah, and again, they're just so it's clear, you can't blame Judge Bork for these observations.
No, this
Maybe
is
I'm right. Yeah, right.
no. These are
right. So of how people have conflated them. But the other one that first I think drove me to a bit of distraction, as I think maybe Deborah Garza will recall, was the fact that look, we always recognized in the 1980s that part of the brilliance of the antitrust paradox and using consumer welfare as the touchstone of antitrust was its semantic power. I mean, we got, the Supreme Court in Ryder v. Sonotone basically embraced that, so that gave us in the Reagan administration the ability to say, see, the Supreme Court agrees with us that consumer welfare is the touchstone of antitrust, and ever since it pretty much has been. But again, we always thought of it as total surplus or total welfare. And but by putting consumers on it, it actually was semantically pretty powerful. And the people who were promoting social and political goals, had a real hard time dealing with it. Well, what happened subsequently, I think, is that people who were not entirely comfortable with the recognition of value that could be created, efficiencies that could be created, essentially pointed out that consumer welfare really should be viewed as synonymous with consumer surplus. And that, and part of that goes along with this notion of price. That the question is, what kind of impact does a particular practice have on price? And it leads to, for example, believing these models are going to generate accurate answers about what will inevitably happen to price. And it also kind of supports the notion that actually existed before the paradox, that the paradox was intended to overturn, of ignoring the value that can be created from productive integration. At least for discounting it and for limiting what its relevance is. And again, I think, you go back and read the book, and and I'm not sure that people, notwithstanding that a lot of people have the book, actually read the book because, again, that's very antithetical to what Bork was trying to do, and in some ways, to quote another Chicago schooler, maybe the founder, Ed Levy, that he used to teach in his foundation of his legal elements class, was the notion that to some extent by converting the term consumer welfare to consumer surplus and by focusing on price rather than output, in some ways you can look at some of the arguments that are being made by people who take that position that look a lot like the old wine pre-antitrust paradox poured into new bottles. And so the semantics matter, and sort of, but what's more important than the semantics is the reality of what Judge Bork was reporting on and the observations he was reporting on, which I think are still accurate. But you got to go back to the original source as opposed to the way the term has been distorted over time by people who, frankly, in the 1980s were fighting us when we were trying to bring those principles to bear in enforcement.
I would love to tell one little anecdote of the pre-paradox world. When I was Deputy Attorney General, I found out to my astonishment, this is 1974, 75, that every single antitrust case brought by the Justice Department, every single one, had to be approved by the Deputy Attorney General or the Attorney General. And I asked, why in God's name is that so? This involves all sorts of cases brought which have no particular policy significance. I was told this was a direction of Roosevelt's, and it was designed to prevent politically embarrassing lawsuits.
Which Thurman Arnold was well known for, so that was the thing. He tended to go after the
I can go on. I can go on and telling those stories, but I won't. This is, after all, a substantive conference. Well, now, how about questions to our panelists? I think the gentleman coming to the mic is.
I think he's leaving.
He's leaving. No, he's sitting down. Please come up, mention who you are, and then throw the panelists your question.
Sure. Matthew Schmidden from Macon Gump. I think this would be for Mr. Rule. So I want to jump into the sort of the delta between you and Dr. Wright on the idea of sort of a Borkian preference for simple administrative rules versus sort of the...
Could you speak louder?
Certainly, the prominence of economists, specifically in the merger context. In at least the body of law that we have now, the simplest and most administrative rules would be those that in marginal cases would tend to lean toward enforcement rather than against it. You know, the simplest rules are those based on market shares. You cross a threshold, it creates a presumption, et cetera. If we were to reform the law to sort of jettison, you know, supply curve models, competitive effects models, and just rely on what the law has given us in terms of simple administrative rules, do you think that would inexorably lead to more aggressive merger enforcement? And if it didn't, what would be the simple rules that sort of stop that from happening? Because if that were the case, to use Dr. Wright's nomenclature, the error cost would be pretty high.
What do you think, Andrew?
Oh, well, I thought that was for Rick.
Well, I you know, very briefly, look, one of the things we were doing in the 1980s, there were more guidelines that came out at that point. I know that, and I've seen that people have criticized, for example, we had vertical merger guidelines that haven't been changed since 1984. And those were attempts to sort of come up with rules that would you know, essentially challenge those transactions that substantially lessen competition based on what I'll call heuristics. And there was a great deal of effort, you may have heard of this from some of the people who were there at the time, of trying to come up with heuristic rules. Because the other thing that was going on in the late 70s and the early 80s is the world really was divided between everything that was per se unlawful, which was a broad category of conduct, most of which has been cut back to horizontal agreements not to compete. And then the rule of reason. But at the time, the rule of reason was meaningless. And so it largely meant that it was lawful. It was almost per se lawful. Mergers were a little different because you had the merger guidelines, which got updated first in 1982 and then in 84 and kind of reflected the ability to come up with some heuristic rules that over time, you know, I think are pretty good. I just think that the notion of giving it over to the economists and thinking that you can predict the outcome of prices is a little bit of a fool's errand. But I think that those kind of rules are effective. I still think that finding heuristics on the rule of reason side, courts have made progress in that regard. The antitrust agencies have made progress in that regard. But I think that's the way to go, so that you look at things like market share, market power, concentration, ease of entry, the effect on, essentially trying to judge the effect on output. And you can't come up with those rules. But that's really sort of what we were trying to do in the 1980s. That's why we had the guidelines. That's why I gave a bunch of speeches. If anybody cares to go back and look at these, they're hard to find these days. But the whole point was we were trying to explain how these different rules apply in different areas. Not so that, notwithstanding we take a lot of grief in this regard, we were not trying to shut down enforcement. We were trying to make it reasonable and form it in a way that made sense given the institutions that had to impose it. And you can do it. It's just that you can't turn it over to an economist and say, well, tell me the answer. Because the fact is, the other thing that you'll find with most of us lawyers, and a lot of companies get in trouble with this, because a lawyer will go to an economist and say, well, give me the answer, go in and tell the story. Lawyer doesn't understand it. The economist tells the story. There's a way to pick it apart so that, like, for example, taking efficiencies out of it, you show, lo and behold, your own model says that price is going to go up. And so it's become kind of a problem. I get why economists like it, because it's greatly enhanced their market value, I think, since I was there in the 1980s. But I just think that, that insight remains just as important today as people think about the rules that they're imposing. And again, it's not because there should not be any enforcement. It's just that you should have an enforcement that's efficient, that where the benefits of that enforcement outweigh the costs.
Andrew, you have a view on that?
I do actually have a view on it. So I think it's important to distinguish between two things. One of them is what I think is the Judge Bork view, that economics has a huge role to play in making the decisions about what the policies ought to be. And then there's implementation of those policies. And the question one could ask is whether or not we've gone to the other direction. The other side of the distinction is economics playing a role in the application of those policies to individual cases, and whether or not simple rules or guidelines or heuristics are better suited to that task, and whether we are too much in the latter world and not enough in the former. And I think that it's not a binary question, it's striking the right balance. And that's where I think there's healthy room for debate, and I think always room for improvement and refining how we strike that balance.
Let me ask you a question about enforcement. When you're dealing with uncertainties, how does that bear on enforcement?
Well,
which way do you lean?
Well, you lean. Well, I think at the end of the day, you lean against making bad law in the long run, right? So that it's they're individual cases and individual case outcomes, but as an enforcement agency, you have to think not just about this case or winning this particular case, but the impact of that decision, that enforcement action on the whole line of future cases that the agency might try to bring. So in some sense, I think the uncertainty makes you lean against making mistakes because of the follow-on effect. You have to remind yourself when you go from private practice back to government and back and forth that when you're in government, you don't have a client that just wants to win that case. You have a client that wants to do not just the right thing and for the taxpayer, but wants to focus on the development of the law for all the future cases and enforcement actions to come. And that affects your decision-making when faced with uncertainty.
Anybody? Oh, yes, we have some questioners.
Thank you. Brooks Harlow. I'm a telecommunications attorney, and I've had some interesting. Can you hear me okay?
Not quite. I didn't
I'll get
hear
closer.
who you were.
I've had some interesting cases.
No, but who are you? Who are you?
Brooks Harlow, telecommunications attorney, and I've had some interesting vertical cases against Bell come out over the decades. So I look with interest, but from afar, at the Judge Leon decision in AT&T Time Warner. But now I'm really focused on Sprint T-Mobile, which was filed with the FCC Tuesday. fun Tuesday night. So my question is, really don't go back to the AT&T Time Warner. T-Mobile, Sprint, should we even think about AT&T Time Warner, or should we ignore it because that was vertical and Sprint T-Mobile is horizontal, so it's a whole different animal? Thoughts?
Well, you'll excuse me if I deferred on that one.
Of course.
Any panelists want to?
Well, you might excuse me if I defer as well, but I really can't comment on AT&T Sprint T-Mobile because it's a pending investigation, and obviously we're disappointed by Judge Leon's decision in AT&T Time Warner, and thinking about appropriate next steps. Beyond that, I would welcome the thoughts of some of the other panelists
Yes,
who've read the opinion and may have a view.
Rick, do you have a view? Susan, do you have a view?
No, not on AT&T Time Warner.
No, he really is
Yes,
asking about.
Yeah, so I do on Sprint T-Mobile because our firm represents T-Mobile. So I think.
So you think it's fine?
So I think it's a terrific merger. It's an excellent, excellent for consumers and should be passed pronto.
But the question is, what is the impact of the AT&T Time Warner on your merger?
Well, I do think that horizontal and vertical mergers get viewed pretty fundamentally different, and so I don't actually see any immediate impact of the one on the other.
Next question.
Henry Hetker, retired government. I wonder
Retired what?
Federal government. I'm not a lawyer.
CIA?
No. Well, what my question is based on yesterday's Supreme Court decision on the online activity of not charging a sales tax when there was no physical presence in the state, and it gave an undue advantage to the online companies versus those that have a physical presence in any state, a rather substantial overhead. Do you have any comments on this? The press has already indicated Amazon says third-party sellers will now have the sales tax deducted or added to the cost of the merchandise, whatever is sold. They say the mom and pop shops will now have a little better advantage than they have had recently.
You know what's interesting about that? It may well be that the impact, the negative impact, would be felt more by mid-size companies that are just getting into the business of internet sales than it would be Amazon, who's big enough to do the complicated work of trying to figure out how to pay all the taxes and would have an enormous advantage over other internet providers. One thought that occurred to me.
Yes, the president's indicated that Amazon has had an unfair advantage with the Postal Service, being able to obtain a contract and being able to produce the shipment of their merchandise at a rather advantageous price, which hurts other companies.
Anybody have a comment on that? I think you're getting up a bit of field. Any other comments? Here they come. Yes, ma'am.
Should I go ahead? My question is about the price versus output. I mean, I think Bork is frequently misunderstood, especially by his critics today, as being too price-focused, and that seems wildly far off from his output focus. They might be two sides of one coin, but I think in areas like resale price maintenance, you can see some differences. So I'd be interested to hear from all the panelists about how you see that difference playing out in enforcement and how the agencies have been looking at price versus output and whether there actually is a balancing in some cases.
The one thing, and I'll just mention one because I think there are a number, but the principal one is the way efficiencies get treated. The both changing the meaning of consumer welfare and focusing on price has provided an excuse for saying that the only relevant efficiencies are those that actually lower price in the context of a merger. If you go back and look at some of the debates that occurred before the 1990s, Oliver Williamson has got some very good analysis about this. There are efficiencies that can swamp a price increase, even when prices go up, if you're focused on overall output. Now, again, who knows why these things happen? They did happen, though, to some extent in administrations that maybe didn't put a lot of emphasis on the things that the Reagan administration did. And they said, well, we're actually taking efficiencies into account, but only in the way that they ought to be taken account because of price. And again, I think they've cited Bork, but I don't think that's a true reflection of what Bork was saying. And again, I think there's also this notion that I've always had a problem with it. If you go to the department or the FTC and make those kinds of arguments, the lawyers will automatically embrace any model that shows that price will go up. But they will also automatically and very aggressively resist any argument that there's an efficiency and create quite a burden to try to prove it. And that burden is even greater when you have to show that it's actually going to offset any effect that a model might show of price going up. So that's one example that, in real life affects those of us who have to deal with the agencies.
I think that's an area we certainly agree. I've got a dissent somewhere in an FTC case and the RDOG merger, which is essentially this point, right? Sort of a asymmetric standard with respect to evidence of price increases versus efficiencies. And I think one cause of that asymmetry is exactly what Rick points out. Another area I think where this potential price versus output tension arises is the use of bargaining models in antitrust applications, which are becoming more and more common, more in vertical cases than in horizontal, but in horizontal we use them, hospital mergers and the like, sort of more and more often. So I've got some model of a bargaining outcome between the merged firm and an input provider that shows the price changing, and I use that price change to try to predict what actually happens in the output market. I think it is a fair criticism to say that economists are sort of, the bargaining models sort of do what they do, but the link between those are usually tucked into exactly the type of merger sim Rick and I sort of agreed sort of is built to show price increases. But there you'll often have price effects and no showing of output effects, and a focus on price kind of while hiding the ball over output. I think that is an area increasingly in vertical cases and some of the healthcare cases where there's bargaining with an insurer underlying the issue, where that is going to be an issue that's going to surface in these cases as particularly important, I think, in the years to come.
Andrew, how is the relationship between the Antitrust Division and the FTC these days?
Well, the relationship is very good. In fact, it's very good. The relationship is very good. I have, as Rick knows, because Rick and Joe Simons and I were all partners together at Paul Weiss not too long ago. Joe Simons was a mentor of mine when I was a young lawyer at Paul Weiss after I left the division the first time. And I think the relationship is going to be very strong.
It has not always been true.
Has not always been true. There will always be, wrinkles here and there. But we've known each other for a long time, as have Macon and Joe. So I think it's going to be a good relationship.
Next question.
Good afternoon. Nick Siebert, Georgetown law student. I'm a disciple of Steve Salop, and I was wondering, could you speak to Bork's legacy on the raising rivals costs model and sort of modern game theory thinking on exclusionary conduct?
I'd be happy to.
Please.
I'd be happy to. So I am not a disciple of Steve Salop's, but we are buddies. So I would say the following, and this is related to some of the remarks I said earlier. One of the things that Steve recognizes in his own writing is that thinking out of the Chicago school itself anticipated most of the raising rivals cost arguments. Bork certainly did in talking about abuse of government process to raise the cost of a rival. Gordon Tullock in the 50s, much of his work on rent seeking was really, and Professor Salop credits him with the same, was really talking about raising rivals cost style arguments before the IO literature picked up on it. And if you look at, I think, closely at the work of Levy and Director, and also in the Antitrust Paradox itself, there are a couple of places highlighted intensely in my copy. I promise I have read it. That talk about accepting some of those arguments in theory, but dismissing them on empirics. And this is part of where my comments about sort of embracing of the empirical evidence being part of the Chicago tradition. They both accepted the theoretical possibility of those raising rivals cost arguments, although not adopting sort of the game theory nomenclature or analytical framework, and said, hey, this is an empirical question. Their prior was, this stuff just doesn't happen, or at least it doesn't happen enough. And there's some debates over whether the right legal rule is per se legality or just, lose on the rule of reason most of the time. But I think they converted it properly to an empirical question. If you look at the modern empirical literature on how common anti-competitive vertical exclusion is, LaFontaine and Slade, or the piece by Luke Frobe, who's currently DOJ chief economist, and some colleagues, their conclusion is not too often. And it's hard to fault guys who said it's an empirical question and who endorsed a policy conclusion that said, let's treat it like it doesn't happen often. Turned out they were right, at least according to the modern literature. Steve and I would probably debate how often it happens, but the economics literature, I think, is pretty clear that this is the exceptional case, and there are important legal questions about how to handle the exceptional case. It doesn't mean that the thing has to be per se legal or that there aren't good cases to bring and litigate, but I don't think Bork or Easterbrook or Levy, a director, would say there's no such thing as a good vertical case, just that they're rare.
I'll add that I actually anticipated this question, and I looked at Antitrust Paradox last night, and I don't know if they're going to be the same passages, but I had the same reaction, actually. When you look at it, there are places where the seeds, I mean, the phrase raising rivals costs certainly isn't in there, but the seeds of the idea are there.
Well, Obergruppenführer, are we all through?
We're not through yet. We've got a few minutes before lunch is ready downstairs. I thought I'd ask a question, if I could, and that is the panelists' views, or if they want to channel Judge Bork on antitrust in the technology world, the fast-moving world of technology where things change so quickly. Does that present a challenge for assessing consumer welfare? Or should antitrust take a lighter touch in that arena?
Andrew, what do you think?
Yeah, sure. I'll start because we've obviously thought a lot about this, because it's one of the issues du jour right now is whether or not antitrust is up to the task of dealing with. Sometimes people call it big data or all of the challenges of technology. It is an issue du jour, but if we go back to the Microsoft case, there were similar questions back then. There are new types of devices, new types of products, and I think antitrust was up to the task then. I think that the antitrust laws are up to the task now. I'm not one who tends to agree with those who say that they're inadequate and there needs to be some broad revision to antitrust law or policy in order to deal with with the challenges of high technology, or whatever you want to call it, big data, emerging technologies. I think we've got the tools we need, and we should continue to apply them with the insights of economics as we've been trying to do.
Do you agree, Rick? Oh, Susan.
Yes, I guess I would say that, I mean, high-tech mergers, for example, are one area where sort of the fact that you can measure price causes it to be overweighted often. And so, when you think about non-price effects, I think the economists would tell us there's not the same reason to assume that sort of any kind of presumption of increased competition, of increased concentration, having the same kind of effects as it does on price. And so, I think economists, including ones who have served in the Obama administration or in the Clinton administration, like Michael Katz, had said, for when you're assessing non-price effects, perhaps we should be moving efficiencies forward to be examining it at the same time as we're looking at these effects. I think there hasn't been enough done, honestly, towards sort of taking efficiencies into account in non-price, when assessing non-price effects, and when you're looking at dynamic markets, that can have a very strong tendency to overweight the short term and the static and the price relative to dynamic efficiencies in the long term.
Both of you have mentioned this. Don't you think it's in part that the overweighing of price vis-a-vis efficiency happens in part because it's easier?
Yeah, I mean, it's definitely a lamppost light problem. Mm-hmm. Sort of you're looking for, I mean, you're looking around for the keys because that's sort of where the prices are something measured for economists to stick in there.
Go ahead, sir.
Yes, thank you, Judge Silverman. Ryan Brown, Rosetta Stone. The previous gentleman actually took my question, but I have another one. This panel has spoken very eloquently about the effect of Judge Bork's book on the U.S. regime for antitrust. Has Judge Bork and the American regime affected other countries? As a global company like mine, we're subject to many other jurisdictions. And do you see the international community coming towards the U.S. Antitrust regime or away, or is there no trend and it just really depends on where you are?
Yes.
Since I haven't said anything about this, I'll take a shot and then some others can. I tend to agree with what the other panelists have said, maybe with the exception of Josh. I mean, my experience, again, as a private practitioner, is a little distressing. I'd like to think that, the U.S. experience, because it's longer, and it does reflect, I think, has been said earlier, a lot more mistakes, that people outside the United States would look to us and recognize that part of the reason the antitrust paradox became so powerful is because it was measured against experience and a recognition of the problems of not having as structured and focused an antitrust regime, and how that really could be inconsistent with the notion of competition. One of the anecdotes that I always like, to tell people in the bar, because it probably matters more to them, it's interesting that, before the 1970s and the Wynne effort by the Ford administration, which you may remember, I'm sure, the state AGs really were not involved in antitrust enforcement. And one of the efforts of the government at that point was to seed the state AGs and get them involved in enforcement. Different people have views about how beneficial that has been. It didn't necessarily follow along with the antitrust paradox. But the same thing happened in the 1990s. The reason that the number of jurisdictions went from only a handful to 144, or whatever the number is large part because of us. And the problem is, and I think this is a function of what you're seeing in the trading world and everything else. In many cases, the PRC is one example, it's truly a paradox to try to put a competition regime on what is fundamentally not an economy based on free market capitalism. And it creates certain distortions, and there's an argument that the way they enforce the law is designed to sort of, supplement or complement their system. And it shouldn't be any surprise that they're going to use rules differently from the way we do. And it does become much more of a political weapon because their economic system is much more political and based on state control as opposed to individual control. So, I wish everybody would follow kind of what we do. I think what we do shows, lessons learned about what works best in a free market economy. But what you got to recognize is that of those 144 countries out there, they're not all free market capitalist economies. And so expecting them to follow the antitrust paradox is probably a little naive. And it reflects the fact that we've put a tool in their hands that's pretty powerful. We're going to have to deal with it, but you can't expect them to wield those weapons in the same way that we do.
Maybe just to pick up also on I mentioned the transnational law course that I took, just to kind of elaborate on that. The way antitrust was portrayed there was that it was an extension of America's industrial organization policy, and which was then compared to, maybe arguably unfavorably compared to Japanese and European industrial policy, which had, I think from the professor's view, more enlightened approach of sort of government-private partnerships, and wasn't that sort of, and so if you're even in sort of capitalist societies, you're imposing antitrust rules on industrial policy history of the part of the role of the government is to be helping suppliers. One of the powerful parts of Judge Bork's book, and I think Rick has sort of mentioned the power of talking about consumer welfare, is, I think he did an outstanding job of making it clear that if you're saying it's going to be something other than consumer welfare, implicitly you're saying we're going to make consumers poorer so that we can make somebody else better off. There's a direct trade between producers and consumers. I think that had enormous power in the United States, but when you move to a society where the norm is that part of the government's role is to be protecting producers, it's always interesting, sort of even with competition lawyers, talking with them about, sort of when Uber arrives in Paris, sort of the very first instinct of the judges is, sort of concern for the taxi driver as opposed to sort of the advantages to the consumers who live in dangerous parts of the suburbs where taxi drivers don't go. So I think it's still quite early on, I think, in some of those countries where antitrust really has only been even in place often for 20 years or less.
I'm afraid, uses up all our time. It is now 12:15 when I was told that must stop, I think for food. So thank the panelists. They did a wonderful job.